it's time for you to decide. You've learned a bit of information. You've determined that the case is still timely. Now you begin to formulate in your own mind that this person may have a basis for a case. So what do you do at this point? Now you've got a choice. And remember what I asked you at the very beginning? I said you can turn around and say, hey, I handle trusts and estates. I handle real estate transactions. I'm a bankruptcy attorney. I don't do any of this stuff. Go find somebody on your own. Yes, you can do that. But wouldn't it be better, wouldn't it be more helpful if you turn around and say, you know what? I now have an option. One option is I can take the case on myself. And if you're willing to do that and able to do that, fine. But just make sure you know what you're doing and have the confidence and ability to know what you're doing and what you should not do. Okay? If you choose to send the case out and refer it to an experienced med mal attorney who does this every day, I have to give you some advice about what you need to look for when you're deciding who to send it out to and where. Okay? Because this is important. So now you've made the decision in your mind, you know what, I'm going to refer it out. So before referring it out, you need to know that the attorney's fee in a med mal case is significantly different and less than in an accident case. In a typical accident case in New York, the attorney's fee is a third after expenses. In a med mal case, the attorney's fee only starts at 30% and drops in increments by 5% until you reach a cap of 1.25 million. Anything above that is only 10%. So it's a sliding scale. So knowing that there's a sliding scale, typically what happens if you refer a case out is that the attorney that you send the case to, if they're successful and get money for the client, let's say they get a 20% attorney's fee. You will then get 20% of their 20%. You get a sliding scale of their sliding scale. But you should also know, there are some attorneys in New York who choose not to take a referral fee, either because of their law firm policy, or they just want to be a good person and say, you know what, for whatever reason, I don't want a fee, and that's fine. But you have to make that choice. And if you decide to accept a fee, now you have to know the other things associated with that. In order to justify getting a fee, you have to be able to show that you have done some level of legal work. Now, what exactly does that mean? Well, that's subject to interpretation, and some law firms interpret it differently than others. The fact that you meet with a client for an hour and now get all their detailed information and intake, some firms would say that's some level of legal work. If you get the patient's medical records, that may be some level of legal work. If you refer the case out and now you are kept in the loop with communications with the client and the other firm, some firms would say that is some level of legal work. If you refer the case out to another attorney, you need to make sure that when they send out their retainer, two things happen. One, that you are included in their retainer, which says that you assume joint representation of this client. You must do that. And two, that they send you the paperwork to fill out for the Office of Court Administration to protect your rights, that you're now on the retainer, and that you simply sign it and drop it in the mail. Okay? So, what happens if you decide to refer a case out? The attorney says, hey, listen, we're going to take on this case. They put you on the retainer. You must get the approval of the client. So as you are about to send the client out, you must tell them, hey, listen, I'm going to send you to a law firm that handles these cases on a regular basis. I'm not qualified. I don't have enough experience doing this. Is that okay with you? They will always say yes. But I also want you to know, and you must tell them, that if you are successful and the attorney, the firm we're sending you to, gets you a good result, there is an attorney's fee that they will receive. And because I am now sending you to them, I will then be receiving a small percentage of what they receive. And in almost 100% of the time, the client will say, fine. They don't care because it's only one attorney's fee. But you must tell them. If you don't tell them, you could run into a problem later on. And it's so easy just to tell them that. And you have to ask the law firm you're talking to, hey, do you guys tell the patient, tell the injured client, listen, there's joint representation. If we get a fee, the attorney who referred us will also get a small percentage. Is that okay with you? And they will sign and acknowledge that. The moment that happens, you're fine. What happens, though, If you decide this person doesn't have a good case, let's say it's not timely, you've come to the decision that their case, the statute of limitations has expired. What obligation do you have? Can you simply turn around and say, "Bye, Mrs. Jones, have a great day"? No, you can't. Because once you have engaged them in conversation, and I mean more than just a brief, chat. I'm talking about once you've invited them in and spent a good deal of time with them. Now, the client may think that you are their attorney, even though you tell them, "Hey, goodbye, I can't help you, I can't represent you." You have an obligation at that point, and it's one you better keep in mind. And that is, you have to send them a rejection letter, a letter declining representation. Now, this letter you must send it out the following way. It must be sent out certified mail, return receipt requested, and regular mail, because you always want to make sure they get a copy, and you never want to have an issue. And contained in that letter, you must include two things. You need to know, Mrs. Jones, that you have a finite time to bring a case against a private hospital or private doctor in New York. You need to go ahead and speak to another attorney immediately to get another opinion. What happens if you don't add that last part in? Sometimes the client may think that you are the be-all and end-all of everything related to law, and you are the God, you are the spoken word, and if you tell me I don't have a case, then I don't have a case. Well, guess what? There may be an attorney down the street who has a different opinion, who thinks you have a valid case, who thinks it's timely, who would have taken the case had the client gone to them with time still on the statute. So what can you do to prevent a problem from occurring and getting a legal malpractice claim? You put in that letter, "Mrs. Jones, I highly suggest you speak to another attorney immediately to protect your rights." That's it. Now they know that you have recommended that they speak to another attorney, and now you're good. So that's what you need to do if you are going to reject their claim.